Imagine your family gathering after you're gone. Your wishes seem crystal clear. You always told your daughter she'd get the house. You promised your son your vintage watch collection, but because one single document is missing, none of it matters. Instead, the home you promised your kids is being appraised for a forced sale. A stranger in a black robe is deciding who gets your most treasured possessions. And your family's private finances, they're on display for the whole world to see. This isn't a movie script, and it's what really happens when you die without a trust and the state takes control. For one family, this exact nightmare became a devastating reality that tore them apart. I'm estate planning attorney Mike Smith with Smith Barid LLC and the Estate Planning Guys. When you pass away without a trust or a will, the legal term is intestate. What that really means is you have no legally binding instructions for what happens to your stuff, your home, or who even takes care of your minor kids. And in that moment of legal silence, the state steps in and takes full control. Your wishes, your promises, your intentions, they're now legally irrelevant. Instead, your entire life's work is handed over to a court system called probate. Your assets are then divided up according to a generic one-size-fits-all formula known as intestate succession. As an estate planning attorney, I've seen the devastation this causes firsthand. These state laws don't know you wanted your niece to have your wedding ring or that your lifelong friend was meant to get a small inheritance. The law just follows a rigid family tree. Your spouse might get a piece, your kids get the rest, but the exact split changes by state and probably isn't what you wanted. Got a blended family? It gets even more complicated, and it could leave stepchildren with absolutely nothing. And if you have no immediate family, your assets could go to a distant cousin you've never even met. In the worst case scenario, your entire estate gets absorbed by the state itself. This isn't your plan, it's a default setting, and it's a recipe for disaster. Let me tell you about a family that I'll call the Millers, and their story shows exactly how this disaster can unfold. Mark Miller was a good man. He worked his whole life, built a comfortable life for his wife and his two children, Sarah and Ben. He owned a home, had a decent savings account, and he ran a small business. He always just figured his family would get everything when he was gone, but he was wrong. When Mark died unexpectedly, the family was heartbroken, but their grief was quickly steamrolled by a harsh legal reality. Because Mark had no trust, his entire estate was frozen. The bank accounts were locked, the business ground to a halt, and the home they lived in was now technically owned by the estate, controlled by the probate court. The first shock was the timeline. Their attorney told them the probate process could take a year or more. In some states or in complex cases, it can drag on for several years. For the Millers, this meant months of uncertainty, completely unable to access the money that Mark had saved for their security. They had to ask a judge for permission just to pay their own bills. The second shock was the cost. Probate is expensive. Court filing fees, attorney's fees, executor fees, appraisal costs. It all starts eating away at the estate. On average, probate can chew up between 3% and 7% of an estate's total value. For the Millers' modest estate, that meant tens of thousands of dollars were going to lawyers and the court system instead of Mark's family. The third shock was the most painful, the conflict. Mark had always verbally promised the family home to Sarah, who lived nearby with her two young kids. And he told Ben that he would get a larger chunk of the savings to start his own business. Without a trust, those promises were legally meaningless. The state's laws said the assets had to be split equally. Ben, feeling the financial squeeze, argued they should just sell the house and split the cash. But Sarah was horrified at the thought of losing her childhood home. The arguments turned into bitter accusations. The siblings, who were once close, they stopped speaking to each other. Their relationship, it fractured under the weight of the court's impersonal logic. And the final insult, the loss of privacy. Probate is a public process. Every asset Mark owned, every debt he had, his business's value, it all became public record, available for any nosy neighbor or scam artist to look up. When you don't have a will or a trust, everything's public, and the family felt exposed during their most vulnerable time. The court eventually ordered the house to be sold to settle the estate and pay the mounting fees, so a stranger bought their home. The remaining money, a lot less than what Mark had left, was divided between his two now estranged children. The legacy Mark wanted to leave, one of security and family unity, was replaced by debt, division, and heartache. Now, if this story is making you uncomfortable, and I hope it is, take a second to like this video and subscribe. The information that's coming up is exactly what will keep your family from ever going through what the Millers did. So how could all of this been avoided? The answer is a simple but powerful legal tool called a revocable living trust. Think of a trust as a private bucket that you create to hold all of your assets. While you're alive, you're in complete control of this bucket. You're the grantor, the one who creates it. You're also the trustee or the manager, and you're the beneficiary, the one who benefits from the trust. You can put assets in, you can take them out, you can sell them, you can do whatever you want, just like you do right now, and nothing about your day-to-day life changes. And here's where the magic happens. When you pass away, instead of your assets being frozen and tossed into probate court, they stay safe inside your private bucket. The person you named as your successor trustee, maybe a trusted child, a friend, or a professional, simply steps in to manage the bucket according to the exact instructions you left behind. The trust document is your personal rule book. It's where you write the story of what you want to happen. So you can say, my daughter Sarah gets the house, but only if she keeps it in the family for 10 years. You can specify that your son Ben gets his inheritance in installments to protect him from spending it all at once. You can leave money to charity, provide for a beloved pet, or gift specific heirlooms to specific people. You can even plan for complex blended families, ensuring that a new spouse is cared for while protecting the inheritance for kids from a previous marriage. A trust is a private contract. The court isn't involved. The state isn't involved. Your nosy neighbors aren't involved because it's not a public court proceeding. It's completely private. And since you don't need a judge's permission for every little thing, the process is incredibly fast, often just taking a few weeks or months instead of years. It lets you sidestep the time, the cost, and the emotional chaos of probate. Now let's rewind the Miller family story. What if Mark had set up a trust? When Mark passed, Sarah and Ben would have gathered, not in some stuffy lawyer's office to hear bad news, but in their family home to grieve together. Let's say Mark had named Sarah as the successor trustee. Within days, she could have access to bank accounts to pay for funeral expenses and handle bills, all that without asking a judge for permission. The trust document would have been crystal clear. The house goes to Sarah, the specific savings account goes to Ben, the business assets are to be sold with the profit split 70-30. There'd be nothing to argue about. Mark's wishes would be laid out in a legally binding contract. There would be no court filing, no public record of their finances, and no tens of thousands of dollars vaporized by legal fees. The assets would be distributed quickly, privately, and exactly the way Mark wanted. Instead of fighting over a house, Sarah and Ben could have supported each other. They could have shared memories of their dad, not argued over his money. The trust would have protected not only their inheritance, but more importantly, their relationship. It would have let them grieve their loss without the added trauma of a brutal legal fight. The difference between these two scenarios is everything. Let's quickly recap the shocking truth and how a trust fixes it. 1. A trust avoids probate court. Dying without one guarantees a long, expensive, and public court battle that drains your estate. A trust completely bypasses probate, saving your family huge amounts of time, money, and stress. 2. A trust keeps your affairs private. Probate puts your family's finances on public display. A trust is a private document, protecting your family's dignity and shielding them from unwanted attention. 3. A trust ensures that your wishes are followed. Without a will or a trust, the state decides who gets what with a cookie-cutter formula. A trust lets you create a detailed, custom plan so your assets go to the people you choose the way you choose. 4. A trust protects your family from conflict. The confusion of dying without a plan is a primary cause of bitter family fights that can destroy relationships. A trust provides a clear legal roadmap that stops those fights before they can even start. Dying without a trust doesn't just mean you don't have a plan. It means you're actively choosing the state's plan. You're choosing to put your family through probate court, public scrutiny, massive costs, and the risk of devastating conflict. The shocking truth is that the real damage is rarely about the money. It's about the chaos, the loss of control, and the broken relationships left behind. A trust is more than just a legal document. It's a final act of love. It's the framework that allows your family to grieve in peace and ensures the legacy you leave is one of care, not conflict. Don't Don't leave your family's future to a roll of the dice. Don't let their story become another version of the Millers. If you want to dive deeper into how to protect your family with proper estate planning, check out the link in the description to visit our resources page. We've got guides, checklists, and all the information you need to get started. And if you found this video helpful, subscribe and hit the bell so you don't miss our next video. Drop a comment below and let me know, do you have a trust in place, or is this something you've been putting off? I read every comment. Thanks for watching.